Hello, Carla Hartley here. Today I am continuing our discussion of the different doctrines that are applicable in family law proceedings. Today's discussion is going to be on the inception of the right doctrine. All right, inception of the right certainly sounds boring, but it's one of those little known areas that I think a lot of family law attorneys tend to forget, and it can really significantly impact your client's recovery or your recovery of your separate property or your share of the community property estate, depending on how this is going. So I'm going to first discuss why inception of the right is so important in family law. That is because we have characterization issues. In family law divorce cases, we don't have this in parentage cases. In family law, we have community property and separate property estates. The community property estate consists presumptively of anything acquired during marriage. That presumption can be overcome if it has been transmuted, which I'm not discussing today, or if it is traceable to a separate property source. Separate property, the separate property estate of a party, is anything acquired before marriage, after date of separation, or during marriage but traceable to a separate property source. Why am I going back over these basics with you? Because inception of the right is most often invoked when we're dealing with assets that the acquisition process began, for instance, before marriage, but was formalized during marriage. Or it began during marriage, but was formalized or received after marriage. I'm going to use two separate examples to discuss this with you. And again, keep in mind I'm dealing just with characterization of the property. My first example is going to be where the inception of the right occurs before the parties marry, but the formalization of the right occurs after marriage. I'm going to use a real property transaction for this. So imagine we have a woman who has contributed separate property down payment to a down payment on a property. It's separate property because she's not married yet. We're looking at, it's 2 months before marriage, and the wedding date is cast in stone. So she has opened up escrow, and she's put her separate property down payment into this property. She has signed the offer. She has signed all the documents that are necessary for her to acquire the property. And maybe she hasn't actually signed the closing documents yet. So escrow, for some reason, we have a hiccup, and instead of closing prior to marriage, escrow closes, say, a month after marriage. And the deed is further recorded after that for some slip up, and the deed gets recorded 2 months after marriage. This is going to be her separate property. She's going to have to prove it's her separate property in all likelihood, but this is pretty simple. The inception of the right occurred before marriage. She made the offer, she put down the down payment, and the application, this is important, the application for credit was all done before marriage, and the credit received, and the credit on which the bank relied, was her separate credit because no community existed. So escrow closes, the grant deed gets recorded, this is still separate property, and it's under the inception of the right doctrine. There are also a couple of other doctrines, but I don't want to confuse this. Now, let's talk about a different scenario where the asset is acquired during marriage, the right occurs during marriage, but the asset is actually received post-separation. For this, I'm going to use a personal injury award as an example. So let's say a couple of years before anybody files for divorce, husband is injured in his vehicle. I'm not going to use job because that's a whole different category. I'm going to use a vehicle accident. So he's injured in a vehicle accident, and And it's not something that's going to, after he's healed up, going to have long-term, long-term consequences for him. But he misses a year. He's got a bunch of medical expenses, and he misses a year of work. He's got a bunch of medical expenses. And by the time the divorce rolls around, by the time somebody files for the divorce, they still don't have the money from the personal injury award. The lawsuit's kind of dragging on a little bit, or the settlement discussions are dragging on. And he's back at work. He's got no long-term medical concerns. I realize I am idealizing this type of an injury, but let's look at what, let's say we're going to have a $250,000 award. That $250,000 is received at the conclusion of the lawsuit or the settlement negotiations, and let's say it's a year after date of separation. Provided that the settlement agreement does not break this out into separate areas, that this much is for, pain and suffering and, loss of work and medical expenses, and that this much is for future medical expenses. We don't have that in this example. If this is just one lump sum and it's for the injury and the expenses that occurred during marriage and there's nothing provided for going into the future, then that is going to be community property, because the inception of the right, the injury, occurred during marriage, the medical expenses occurred during marriage, the lost wages occurred during marriage, and the fact that the recompense to the community isn't received until after date of separation does not make this separate property. Again, I've chosen two very, very simple examples, and I want to be very clear. That's because I want you to be aware of the concept. I am very clearly aware that in most cases it's not this simple. Sometimes it is, but in most cases it's not this simple. And we may have a mixed asset that's part community and part separate. That's what you hire lawyers for. But what I want to do is make sure that you know and that you're aware of the concept of inception of the right, so that if you have this type of issue and you're shopping for an attorney, make sure your attorney knows what that is before you hire them. I hope this has been helpful. I hope this has been, in some small way, educational. And as always, I generally hope that I'm reassuring you that there's hope at the end of your legal proceeding, because it's a good life out there. Sometimes we just have to get you through the tough parts. All right, that's all I have for today. I hope you are having a good weekend, and I will be talking to you again soon. Thank you.